Good afternoon, distinguished guests, esteemed leaders of foreign communities, and dear participants. We are ready to begin our Icj Mock Trial. My name is Shahzoda, and I'm truly honored to be your Master of Ceremonies today. Welcome to the International Court of Justice Mock Trial. For those who may not be familiar with the ICJ, the International Court of Justice is the principal judicial organ of the United Nations. Today's mock trial has been organized to provoke participants with the opportunity to experience international legal procedure, public speaking, debate, and diplomatic discussion in a professional setting. Before we begin, we kindly ask everyone that if you need to leave the hall during the session, please use the back door to avoid interrupting the proceedings. And first, I would like to introduce the leadership team making this event possible. First of all, please welcome the CEO of Iwik, Mr. Kim Ah-sol.
네, 안녕하십니까 여러분. 인터내셔널 월드 인 코리아 대표 김아솔이라고 합니다.
Good afternoon, everyone. My name is Sol Kim, President of International World in Korea.
오늘 2026 Iwik Model Un Icj Mock Trial 행사에 함께해 주신 모든 참가자 여러분께 진심으로 감사의 말씀을 드립니다.
First of all, I would like to sincerely thank all of you participants for joining us today at the 2026 Iwik Model UN Icj Mock Trial.
네, 먼저 이번 행사를 공동 주최해 주신 이재강 의원님과 의원실 관계자 여러분들께 깊은 감사의 말씀을 드립니다.
I would also like to express my deepest appreciation to Assemblyman Lee Jae-gang and his office for co-hosting this event.
또한 오늘 행사를 위해 약 5개월 동안 준비 과정에서 많은 수고를 해주신 RF님과 운영진 그리고 각 팀의 리더와 팀원 여러분들께 진심으로 감사의 말씀을 드립니다.
In addition, I would like to thank Arafe, the organizing team, and all team leaders and members who have worked hard over the past 5 months to prepare for today's program.
이번 프로그램은 다양한 국가의 청년들이 국제사법재판소 모의재판 활동을 통해 국제법과 국제 분쟁 해결 과정을 직접 경험하고 배우는 자리입니다.
This event is a meaningful opportunity for young people from diverse countries to directly experience and learn about international law and the process of resolving international disputes through an international court of justice.
참가자 여러분께서 각자의 역할 속에서 국제법적 관점과 논리를 고민하고 실제 국제재판 과정을 이해하며 글로벌 시민으로서의 시야를 넓히는 의미 있는 시간이 되기를 바랍니다.
I hope that each participant will gain a deeper understanding of international legal perspectives and judicial procedures through their respective roles, while also broadening their global perspective as future global citizens.
특히 서로 다른 문화와 배경을 가진 참가자들이 함께 국제 이슈를 바라보고 준비해온 과정 자체가 매우 뜻깊은 국제 교류의 경험이라고 생각을 합니다.
I also believe that the process of preparing together with participants from different cultural and national backgrounds has itself been a valuable experience in international exchange and cooperation.
다시 한번 오늘 함께해 주신 모든 분들께 감사드리며 오늘 모의 재판이 참가자 여러분 모두에게 국제법과 국제사회의 역할을 더욱 깊이 이해하는 의미 있는 시간이 되기를 바랍니다. 감사합니다.
Once again, thank you all for being here today. I hope this mock trial will become a meaningful opportunity for everyone to better understand international law and the role of international community. Thank you. Thank you very much, Mr. Kim Ah-sol. And next, we would like to introduce to you Mr. Park Yong-san. And also the supervisor and coordinator of today's ICJ, Ms. Arafe.
Ladies and gentlemen, good afternoon. It is truly an honor for me to stand before you today as the coordinator and supervisor of this Icj Mock Trial program, organized by the Office of Mr. Lee, member to the National Assembly of the Republic of Korea, as well as Iwik International Board in Korea. Today's event is not simply the result and outcome of a single day's preparation. It is the outcome of months of dedication, teamwork, learning, and sincere effort that began back in January. From our earliest meetings in Iwik, where we discussed foundation and vision of the project, to the development of fictional legal scenarios, recruitment of passionate participants, continuous training sessions, practices, online meetings, and rehearsals, every stage of this journey was built with commitment and enthusiasm. This program brought together many talented individuals from different backgrounds, including our judges team, the applicant state, respondent state, our secretariat team, and also the organizing committee. Together, we tried our utmost to create a simulation that reflects the professionalism, structure, and the spirit of the real International Court of Justice as closely as possible. However, beyond legal simulation, the purpose of this program has always been much greater. We aim to create a meaningful platform where people from diverse nationalities and backgrounds could come together to discuss global issues, strengthen their communication skills, develop leadership, practice legal reasoning, and most importantly, learn from one another through dialogue and cooperation. As someone who studied international law and has long been engaged in reading and analyzing the real cases of the ICJ, this program has also been personally meaningful to me. It has truly been a valuable experience to mentor and supervise a project that connects legal education with international exchange and practical participation. At this moment, I would like to express my sincere appreciation to everyone who contributed to making this event possible. In particular, I would like to extend my deepest gratitude to the CEO of Iwik, Mr. Kim Il-sung, for his trust and support, as well as Mr. Park Yong-sang, the advisor to the Iwik, for his guidance and encouragement throughout this process. I would also like to thank every member of our teams and all participants who dedicated their time, energy, passion, and sincere effort to this program. Lastly, I hope today's session will not only be remembered as a mock trial, but also as an opportunity to inspire cooperation, understanding, and engagement with international law and global issues. Thank you very much.
Thank you very much, Ms. Arafe, for those inspiring remarks. And next, I would like to introduce to you the judges team leader, Ms. Franziska Dahmen. Please give a big applause. The leader of a party A, Ms. Florence Che. Please give a warm welcome. And the leader of Party B, Ms. Julie Chandler. And our organizing team leader, Ms. Svorva Varvara. And secretariat team leader, Ms. Sontake Mansi Pramod. We are also joined by special guests from various foreign communities across Korea. Welcome, everyone. And before the trial officially begins, we would like to invite our CEO, organizers, and VIP guests to the stage for a commemorative photo session. Yes, please come to the stage. Let's take a group photo all together. Hi.
So it is everybody. It's everybody.
Yes.
And then after everybody, it is them is the organizer Iwik, and then this, and then this, and then secretariat. That's
Okay, party A first and then party B first.
And then party A and party B together.
Together, okay.
And then just them together.
Just them?
Just Iwik alone.
Okay, the CEO and
Yeah,
and
yes.
Arafat. Okay, got it.
So everybody party A and party B, and then party A and party B together, and then just.
Okay, got it. Everyone, let's see some big smiles. Say cheers. One more pose, please.
Okay, so I'm going to say 1, 2, 3. Everybody say kimchi. Okay. 1, 2, 3. We can say Iwik. Ready? 1, 2, 3. Again. 1, 2, 3.
Iwik. Варвара, судьи готовы? Я их буду звать, потому что...
Прямо сейчас?
когда
Мы
все сядут.
подадим знак. Мы подадим знак. Я открою дверь, подам знак. Они будут... Ау, они должны стоять прямо тут.
Пусть они стоят тут. Я Я сначала всех попрошу, чтобы они встали, но я не буду говорить то, что судьи заходят. Я попрошу, чтобы все встали, но я не буду говорить то, что судьи будут сейчас заходить. Хорошо? Сначала сейчас сфоткаются, потом я позову. Хорошо? Я скажу, чтобы они все встали. Хорошо. May I ask Party A and Party B participants please come to the stage for a group photo. Sorry for confusion. Okay, ladies and gentlemen, may I ask you now, the entire audience, to please stand up. Yes, please stand up. The judges of the International Court of Justice are now entering the hall.
I am. Okay, hello. Okay. Good afternoon. The court is now in session. I'm Franziska Dahmen, and to my right and left side sit my fellow judges of this court. We are here convened today on the 16th of May 2026 to hear the case brought by State B against State A concerning the lawfulness of military intervention conducted by State A in the territory of State C beginning on the 1st of January 2026. The court has before it the application of State B and the response of State A. The jurisdiction of this court is established under Article 36, Paragraph 1 of the statute and under Article 4 of the Pact of Peace to which both states are parties. Neither party having contested jurisdiction, the court is satisfied it is properly seized of this dispute. The court will hear the agent of State B first as the applicant. The bench will then put questions. This agent of State A will follow and will likewise be questioned. After a brief recess, both agents will deliver their rebuttals. The court will then retire to deliberate and will return to deliver its judgment. The court reminds the parties that arguments must be grounded in the sources of international law set out in Article 38 of the statute. Agents at all times address the court and will address one another only through the court. The court now invites the agent of State B to present the first round of claims. Madam Agent, Mr. Agent, you have the floor.
Ms. President, members of the court, my name is Caitlin, and together with my co-counsel, I appear today on behalf of State B. This case asks a fundamental question, whether a state may take up arms against a sovereign nation under the guise of humanitarian protection, and whether R2P can serve as legal cover for that choice. R2P is not a rule of international law, it is a political commitment voluntarily adopted at the 2005 World Summit. It confers no unilateral right of military intervention. Where a state manifestly fails its population, R2P's third pillar assigns the responsibility to respond to the international community acting through the Security Council. State A sought no such authorization. And yet, State A not only intervened without authorization, it remains in State C today. No authorization was obtained before the intervention, and none has been obtained since. State A continues to occupy a sovereign territory without any legal basis, making this not merely a question of a past unlawful act, but an ongoing violation before this court. State B will demonstrate four things. First, that only the Security Council may authorize military intervention under the UN Charter, that State A's use of force is unlawful and no recognized exception applies, that non-military measures had not been exhausted, and that the theory State A advances, if accepted, would license any state to wage war across borders under a declared humanitarian emergency. A crisis does not dissolve the law. Urgency is not authorization, and a humanitarian mission does not become lawful simply because it continues. State B respectfully requests the court find that State A's intervention constituted an unlawful use of force, that R2P provides no valid legal basis for it, and that State A has violated and continues to violate its obligations under the Charter and customary international law. Thank you, Ms. President.
Honorable members of the tribunal, distinguished delegates and respected colleagues, my name is Jahangir and I stand before you today to address one key question. Were non-military measures truly exhausted before? State A used military force or position is clearly, they were not. Under the United Nations Charter, force must remain a last resort. Article 33 requires peaceful solutions such as negotiation and meditation, while Article 41 provides non-military measures including sanctions and diplomatic pressure. But did State A genuinely attempt all of those options before turning to war? Did State A fully impose an arms embargo to stop the spread of weapons? No, it didn't. Did it pressure strongest diplomatic isolation and coordinated international pressure? Again, no. Were targeted sanctions imposed on leaders responsible for the violence? There is no clear evidence of that. Was mediation or dialogue seriously attempted before military actions began? No meaningful effort is demonstrated. History gives us clear examples. On 26 February 2011, the UN Security Council adopted Resolution 1970 during the Libya crisis, introducing sanctions and an arms embargo. Yet, but by 17 March 2011, military force had already been authorized. This shows that peaceful measures were not given enough time to work. In contrast, in Kenya, mediation led by former UN Secretary General Kofi Annan successfully reduced violence and resulted in a power-sharing agreement on 28 February 2008 without military intervention. Similarly, on 31 March 2005, the UN Security Council referred the Darfur situation to the International Criminal Court through Resolution 1593, providing that legal accountability can be pursued without immediate force. So we must ask, if sanction mediation and international legal mechanism were still available, how can military intervention truly be called a last resort? In conclusion, State A acted prematurely, non-military measures were not fully exhausted, and therefore the intervention cannot be considered legally justified under international law. Thank you.
Dear Ms. President, distinguished members of the court, good afternoon. My name is Beit Elhim. I will now present the Charter basis for Security Council's central role. The UN Charter creates a centralized collective security system in which only the Security Council has primary responsibility and authority to authorize coercive measures, including force, to address threats to peace, to prevent unilateral humanitarian intervention, violating that system. Article 24, paragraph 1 of the UN Charter states that the UN members confer on the Security Council's primary responsibility for the maintenance of international peace and security, and agree that in carrying out this responsibility, the Council acts on their behalf, on behalf of the member states. The specific powers through which the Council exercises this responsibility are laid down in chapters 6, 7, 8, and 12, which confirms that decisions on peace and security are to be centralized in the Council rather than taken unilaterally by individual states. Chapter 7 empowers the Security Council to determine the existence of any threat to the peace, breach of the peace, or acts of aggression, and then decide binding measures, including non-force measures under Article 41 and military action under Article 42, to maintain or to restore international peace and security. Scholarly analysis of UN collective security system emphasizes that the Council is a political organ endowed with normative powers to adopt measures with legal consequences under Chapter 8, under Chapter 7, making it the institutional core of the collective security system rather than merely on one actor among many. R2P channeled through the Security Council. The UN's official description of the responsibility to protect stresses that when national authorities are manifestly failing to protect their populations, states are prepared to take collective action through the Security Council in accordance with the Charter, including Chapter 7, and only as a last resort. Commentaries on R2P note that the authority to employ force under R2P framework rests solely with the Security Council, distinguishing it from older notions of unilateral humanitarian intervention that claim a right to use force without Council authorization. As seen in the Libya intervention, the use of force under R2P was only considered lawful because it was authorized by the United Nations Security Council through Resolution 1973, confirming that legitimate action must occur within the Charter framework. It can be argued that because members have conferred primary responsibility for peace and security on the Security Council, and because Chapter 7 gives it specific enforcement powers, and any use of force for humanitarian purposes must be authorized by the Council unless it clearly falls under self-defense, and unilateral intervention like State A's bypass this collective system. We'd also like to point out that scholarly debates about creating a framework for non-UN authorized humanitarian force show that at present, the law does not recognize general unilateral right of humanitarian intervention, and that accepting such right would undermine the charter-based collective security system, and it would invite abuse. Thank you.
Madam President, members of the court, my name is Sumin Song, and I appear on behalf of applicant State B. In this round, I'll first define the principle of collective action under international law, then demonstrate how State A violated this principle, and finally address the respondent's claim that urgency justified his actions. At its core, collective action is about restraint as much as it is about responsibility. It means that when a state fails to protect its population, other states act in cooperation. This is clearly reflected in Article 2 of Pact of Peace, in which it states individually and jointly and in cooperation with the competent organs of the United Nations. Even when a state fails to protect its population, the response must remain collective and legally grounded. Independently, no. Selectively, no. And certainly not unilaterally. This understanding was affirmed by the jurisprudence of the same court. In Nicaragua versus United States in 1986, the court held that the use of force by a state cannot be justified by its own political or moral assessment. Instead, such actions must conform to the strict legal framework governing the use of force, including respect for state sovereignty and the central role of the UN system. Now, applying this principle to the present case, State A's conduct falls squarely outside the bounds of collective action. Despite its position being within the UN, State A proceeded without Security Council authorization. By doing so, it did not act for the international community, but instead displaced it, substituting its own judgment for the collective will required under international law. We now must turn back to the specific issue at hand. To understand why Party A has failed, we must look at the narrow corridor through which a state may legally use force. Under the Pact of Peace, the prohibition of force is the rule. Intervention is only the rare and strictly controlled exception. International law recognizes only two lawful pathways for the use of force. The first and most important is the authorization by the UN Security Council. This is the primary and non-negotiable legal mechanism established by the Charter itself. Without a resolution, there is no mandate. The second pathway lies within the constraints of the Pact of Peace itself. Article 1 requires that any action remain consistent with the principles of the UN, while Article 2 makes it equally clear that even when a responsibility to protect is invoked, it cannot override the Charter's prohibition on the use of force. Furthermore, force is always a measure of last resort. A state cannot claim it had no choice when diplomatic negotiations had barely begun and economic sanctions had not even been given the opportunity to take effect. Yet, that is precisely what Party A has chose to do. So how exactly has intervention failed? There are four distinct counts. First, by the action's unilateral nature. A small coalition of willing states cannot substitute itself for the collective judgment of the international community. Second, the absence of authorization. The Security Council did not adopt a resolution approving intervention. Under international law, silence from the Council is not implied consent. It is a legal sign to stop. Third, by entering its territory without consent, Party A violated sovereignty and territorial integrity of State C. And last but not least, Party A acted in direct contradiction to Article 2 of the UN Charter. One cannot preserve the legal order by dismantling the principles that sustain it. Now, Party A attempts to justify these actions through claims of urgent humanitarian necessity. Civilians were dying, displacement was escalating, and thus immediate action was necessary. One thing must be clear, the applicant does not deny that lives were lost and that others were placed at severe risk. However, the urgency, no matter how real, does not rewrite the law. It does not create a legal exception to the prohibition of the use of force. The national legal system is already designed to address these urgent issues. The UN Security Council itself exists to respond to these crises through cooperative measures, which ensure that even in times of emergency, decisions must remain legitimate. Even in the present case, with all the diplomatic efforts, sanctions, and Security Council discussions, this is not a situation where collective action was absent. State A just chose to bypass it. Allowing such conduct was such a dangerous precedent. If urgency alone were sufficient to justify unilateral intervention, then any state could claim necessity and act outside the law. The prohibition of the use of force would cease to act as a binding rule and would instead become optional, invoked only when convenient. And finally, we must examine the reality on the ground. If this intervention was truly limited and humanitarian nature, why does Party A continue to occupy State C? Crucially, even if the initial inclusion has been justified under a veneer emergency, State A's prolonged ongoing residency within State C operates entirely outside the bounds of international oversight. The shift from the so-called rescue mission to prolonged occupation exposes the true character of this operation. What began under the language of protection has evolved into an exercise of control. In conclusion, the responsibility to protect does not grant states the authority to act unilaterally. Instead, it imposes a responsibility to act collectively within the framework of the international law. So I'd like to say, Madam President, if the court validates Party A's action, it signals the end of Pact of Peace. It tells the world that a state's feelings about a crisis is more important than the laws written to protect war. we ask the court to uphold the sovereignty of State C and declare parties' intervention as a violation of international law. Thank you.
Ms. President, members of the court, my name is Julie Chandler, and I will be presenting the closing argument on behalf of State B. State A will appeal to the morals of this court. However, this case was never about whether suffering existed in State C. State B does not deny the harm faced by civilians or civilian forces in State C. However, urgency is not authorization. What this case asks is far more consequential: whether the existing of suffering allows a state to disregard national law. Over the course of these proceedings, one point will remain constant. State A did not act within the law. It acted outside of it. It bypassed the United Nations Security Council, the only body entrusted with authorizing force on behalf of the international community. It ignored collective security systems established by the Charter, and it substituted cooperation with unilateral decision-making. Further, it is claimed that the intervention was a last resort, yet peaceful measures of resolution were not yet fully exhausted.
Counsel, you have 5 minutes remaining.
Thank you. Diplomatic engagement, sanctions, and coordinated international pressure were still unfolding, and critically, State A did not meaningfully contribute to those efforts, nor did it attempt any additional peaceful measures after the situation escalated. State A stood apart from collective processes, made no effort to personally resolve concerns, but now invokes their supposed failure as justification for invasion. State A will also invoke the responsibility to protect. But R2P does not authorize unilateral force. It requires collective action through lawful channels. By arguing that R2P was applicable in this case, State A is misinterpreting a political goal as a source of legal authority. Furthermore, justifying R2P that depends solely on a state's unilateral humanitarian judgment would open the door to an abuse of power. If this justification is accepted, then any state could claim urgency, invoke humanitarian language, and cross borders with force. The prohibition on the use of force, one of the clearest and most fundamental rules of international law, would become conditional, subjective, and ultimately meaningless. State A is therefore asking this court to accept a dangerous precedent, that a state may decide on its own when international law no longer applies to itself. This is not a small shift, rather a threat to the international system, the checks and balances that keep us all safe. The court has rejected this logic before. As previously presented in the Nicaragua case, it was made clear that neither political motives nor moral claims can legalize unlawful use of force. That principle remains unchanged. For these reasons, State B respectfully asks the court to reaffirm the integrity of international law and to find, 1, that State A's intervention constituted an unlawful use of force. 2, that its invocation of the responsibility to protect provides no legal justification.
Counsel, you have 1 minute remaining.
And 3, that it has breached its obligations under the United States Charter and applicable international law. Ms. President, members of the court, the case before you is simple. This case is not about choosing between law and humanity. Law exists to protect humanity, but it does this through rules, through structure, and through collective decision-making, not through unilateral discretion. Thank you.
Madam Agent, State A reports that 14 months prior to the intervention, the international community pursued diplomatic measures, mediation, and economic sanctions. during which time 50,000 civilians were killed and 2 million displaced. On State B's view, what additional peaceful measures could realistically have been pursued, and for how much longer before further inaction itself would have become untenable?
Council, you have characterized R2P as political commitment. However, Article 2 of the Pact of Peace, which your client signed, explicitly states that each party bears the primary responsibility to protect its population. Thus, the inclusion of this language in a binding treaty not transform R2P from a political goal into a positive legal obligation for the parties involved. Thank you.
The court thanks the agent of State B. The court now invites the agent of State A.
Good afternoon, Ms. President, honorable members of the court. My name is Florence Che, appearing on behalf of State A. With me are my co-counsel, and we are prepared to present our submissions before the court. Now, with the court's permission, I now invite counsel for State A to deliver the opening submissions.
Ms. President, honorable members of the court, it is a profound honor to appear before you today on behalf of State A. We stand at a critical juncture in the evolution of international law, where the traditional shield of sovereignty is being weighted against the fundamental right of a population to survive. The facts in this case represent a catastrophic collapse of human dignity. State C has devolved into a threat of mass atrocity where the government, rather than protecting its citizens, turned its military might against them. More than 50,000 civilians have been killed and over 2 million forcibly displaced. State C has engaged in indiscriminate attacks, forced displacements, and the deliberate obstruction of life-saving humanitarian aid. Eventually, for 14 months, the international community persuaded every peaceful avenue available, such as diplomatic pressure, mediation, and targeted economic sanctions, all failed to halt the violence. State A submits that its limited military intervention was legally justified under the following pillars. First, as articulated in the 2005 World Summit Outcome document and reflected in Article 2 of the Pact of Peace, every state has a primary duty to protect its population. When a state manifestly fails in this duty, that responsibility shifts to the international community. Second, Article 1 of the Pact explicitly obligates parties to cooperate to prevent and respond to serious violations of international humanitarian law. State A acted to uphold this very obligation when the machinery of State C became the instrument of civilian destruction. Finally, the intervention was strictly limited in scope, aimed solely at civilian protection through the establishment of humanitarian corridors. State A did not act out of desire for conflict, but out of a legal and moral necessity to prevent the complete destruction of protected population. We ask this court to recognize that international law is a living instrument that must prioritize the protection of human life over the procedural inaction of a deadlocked Security Council. We respectfully request the court to declare that State A's actions were lawful, necessary, and consistent with the fundamental purpose of the United Nations and the Pact of Peace. Thank you.
Ms. President, distinguished members of the court, my name is Celine Huang, and I appear before this court on behalf of State A. The applicant argues that State A violated international law because its intervention was conducted without authorization from the Security Council. However, State A respectfully submits that international law cannot be interpreted so rigidly that it leaves the civilian population defenseless during the mass atrocity crimes. This case concerns exceptional circumstances where a government attacking its own civilians, peaceful measures failing for over 14 months, and a humanitarian crisis that continued to escalate. Today, I'll make 3 arguments. First, R2P framework became applicable
because State C manifestly failed to protect its population. Second, State A's intervention was necessary and proportionate under the circumstances. Third, the UN Charter and the Pact of Peace must be interpreted in the light of their humanitarian purpose. First, R2P applies in this case because it reflects the principle that sovereignty is not only a right, but also a responsibility. Every state has its primary duty to protect its population from genocide, ethnic cleansing, crimes against humanity, and war crimes. But when a state manifestly fails in this responsibility, or even becomes the perpetrator of the crime itself, the international community also has a responsibility to respond. This is exactly what happened in State C. Government of the State C actively participated in attacks against civilians. Diplomatic efforts, sanctions, mediation attempts, and other peaceful measures had already been exhausted over 14 months. Despite these efforts, none of the peaceful measures stopped the atrocities. These acts constituted mass atrocity crimes because they involved widespread and systemic attacks against civilians, including indiscriminate violence, forced displacement, mass detention, and the obstruction of humanitarian assistance. Such conduct falls within internationally recognized categories of crimes against humanity and war crimes. The R2P framework, reflected in the 2005 World Summit Outcome document and repeated UN practice, recognizes that the international community cannot remain passive during the mass atrocity crimes. State A is not arguing that R2P creates an unlimited right of intervention. Rather, State A submits that R2P helps explain why the international community's responsibility was so triggered under these exceptional humanitarian circumstances. Second, State A's intervention was necessary and proportionate. Under Article 25 of the Articles on the State Responsibility, necessity may excuse conduct when it is the only available means of protecting essential human interests from grave and imminent danger. This court recognized necessity as narrow but valid doctrine in 1997 Gavshikovo and Nasmarosh project case by acknowledging that states may exceptionally depart from international obligation when essential interests face grave and imminent danger and no other means remain available. That standard was satisfied here. After 14 months of failed peaceful efforts, civilians remained exposed to mass killings and humanitarian collapse. At that stage, inaction would have allowed the crisis to continue escalate. Most importantly, State A used only the minimum force necessary. The intervention was limited in scope and duration and directly solely toward civilian population protection. State A also established humanitarian corridors to provide civilians with safety and humanitarian assistance. In addition, the intervention cannot reasonably be described as aggression. Under UN General Assembly Resolution 3314, it is stated that aggression is generally associated with conquest, annexation, occupation, or political domination. None of those elements are present here. State A did not seek territorial gain or political control. Its actions were temporary, limited, and humanitarian in nature. State A met those requirements of necessity and proportionality. Third, the UN Charter and the Pact of Peace must be interpreted holistically. While State B relies on Article 2, Paragraph 4 of the UN Charter and the Vienna Convention of the Law of Treaty to support their argument on strict prohibition on force, State A respectfully submits that the Vienna Convention actually requires treaty to be interpreted in the light of their object and purpose as a whole. State A fully recognizes the importance of sovereignty and non-intervention. However, the UN Charter is not solely concerned with territorial integrity. It also promotes human rights, international peace, and protection of civilian population from mass suffering. Likewise, the Pact of Peace includes obligation relating to civilian protection and international cooperation in responding to humanitarian crisis. These principles must be read together, not in isolation. State A therefore submits that Security Council deadlock cannot create a legal vacuum in which the international community is forced to remain passive during the mass atrocity crimes. Recognizing a narrow humanitarian exception under these exceptional circumstances would not weaken the international law. Rather, it would preserve the humanitarian purpose and the credibility of international legal system. Distinguished members of the court, State A acted only after peaceful alternatives failed. It acted with limited and proportionate force, without territorial ambition, and solely for the protection of civilians. Its conduct reflected necessity, humanitarian purpose, and good faith interpretation of international law. For these reasons, State A respectfully asks this court to reject the claims brought by State B and find the intervention was lawful under the exceptional circumstances of the case. Thank you.
Members of the court, on behalf of State A, I will now deliver the closing submissions before this court. Now, this case is not simply about the use of force. It is about whether international law can respond when a state turns against its own people and peaceful efforts have completely failed. State A respectfully submits that its intervention in State C was lawful, necessary, and proportionate under the exceptional circumstances of this case. Now, the facts before the courts are severe and uncontested. More than 50,000 civilians were killed. Over 2 million people were forcibly displaced. Humanitarian assistance were deliberately blocked, and State C actively deployed military force against its own people. This was not merely a domestic political crisis. It was a mass atrocity situation that involved crimes against humanity and a classic case of ethnic cleansing. Before any intervention took place, the international community attempted peaceful solutions. Diplomatic negotiations, mediation efforts, and economic sanctions were even pursued. However, these measures failed to stop the violence, and civilians continued to suffer. Faced with this reality, State A acted under the principles reflected in the Responsibility to Protect Framework, R2P. The intervention was not motivated by territorial ambition, political domination, or regime change. It was limited in scope and duration and directly solely towards civilian protection. Humanitarian corridors were established, and the operation remained narrowly focused on preventing the further loss of life. Honorable judges, State B argues that the intervention violated the prohibition on the use of force under Article 2.4 of the UN Charter. Now, State A does not deny the importance of sovereignty. However, sovereignty cannot be interpreted as a shield behind which mass atrocities may occur without consequence. International law must be interpreted as a coherent system. The Charter protects both state sovereignty and fundamental human rights. Likewise, the Pact of Peace must be interpreted in good faith and holistically, in accordance with the Vienna Convention on the Law of Treaties. Now, the Pact itself recognizes responsibilities towards civilian populations and cooperation in responding to mass atrocity crimes. State A further submits that its conduct satisfied the customary requirement of necessity and proportionality. Force was used only after peaceful alternatives were exhausted, only to the extent required, and only for the protection of the civilians. The intervention, therefore, cannot be characterized as aggression or unlawful conquest. The court must also consider the wider consequences of this case. Now, if international law remains powerless while thousands of civilians are suffering simply because international institutions are politically deadlocked, then the law risks failing the very people it was created to protect. International law should not be interpreted in a way that forces the whole world to stand by while mass atrocities occur. It must be interpreted not only to preserve state sovereignty, but to also protect human life, where a state has manifestly failed in its most basic responsibility to protect its own people.
Counsel, you have 5 minutes left.
Accordingly, State A respectfully requests the court to find that 1. State A did not violate international law. 2. The intervention was necessary, limited, and proportionate. And thirdly, no reparation should arise because State A's actions were lawful and justified under international law. Thank you.
Counsel, the 2005 World Summit Outcome Document, which your client itself relies upon, provides at paragraph 139 that the international community is prepared to take collective action through the Security Council in accordance with the Charter, including Chapter 7. How does your client reconcile a unilateral intervention with the very text on which it relies?
Counsel, your client reports that for 14 months, the international community pursued peaceful measures and also cited Gapchikovo Nadimaraj project as to validate the necessary intervention of State A. What was State A's own contribution to those measures? Did State A propose, support, or co-sponsor any draft Security Council resolution during that period?
The court thanks the agent of State A. The court will now adjourn for 5 minutes. Thank you. Wait. The court will actually adjourn for 10 minutes, so you have 10 minutes.
32 seconds. I wrote everything, like at what time. It's like 32 seconds, so we have to.
Actually, you have to make announcement when 10 minutes left, 5 minutes left, last 2 minutes left.
Normally, when they do elements, it's only 1 minute. So I heard about only 1 minute. I haven't heard like 5 minutes.
Because they have to wrap up, like they have their things, right? So when you announce like 5 minutes left, so they start like more reading fast.
So about this break time, am I supposed to announce that only 1 minute left or just stay?
She was saying very strong.
I think because and I can just record, just not record. I am doing like that. So that's what is easy. Ten minutes are over. Break is Can everyone get to their seats, please?
The session is resumed. The court now invites the agent of State B to deliver its rebuttal. Madam Agent, Mr. Agent, you have the floor.
Ms. President, regarding the question about what additional measures could have been used and how much time would have been needed for that. First of all, several concrete measures remained available and were never genuinely pursued to the point of real exhaustion, and rather, as stated before, abandoned as first reactions did not seem to solve the situation. First off, stronger and more targeted sanctions, not just broad measures, but sanctions aimed specifically at individual leaders identified as responsible for directing violence and blocking the humanitarian access. This was never fully applied. For example, there was an NOO coordination international pressure bringing other countries in to apply joint sanctions and diplomatic isolation together. No such coalition was ever assembled, and no other states were sought for support, and the international community was never meaningfully mobilized through legal channels. Second, an arms embargo. Cutting off the weapons supply fueling the conflict entirely could have been another measure, which was never sought for or imposed. Third, an ICC referral, creating direct legal accountability for those responsible for civilian casualties, as done with Darfur in 2005, which was never attempted. Fourth, coordinated international pressure, as mentioned before. There was no active seeking out for the international community to help with joining in for the sanctions or other diplomatic isolation and cooperation. Neither was there sought after a more formal mediation through neutral third-party actors, such as the example Kenya in 2008 proves that dialogue alone is able to end mass violence and without needing a single soldier to cross the border. Finally, the most critically, there was no direct cooperation with State C itself. State C was already actively fighting radical political groups threatening its own sovereignty, and State A never once offered to work alongside State C. They didn't offer resources, intelligence, or any sort of coordination, and never attempted to strengthen civilian protection from within. And instead of knocking on the door, they just broke it down and went in unilaterally. How long would have these measures been have taken? Targeted sanctions can be taken in days, weeks, and to be honest, State A had 14 months, and within these 14 months, these measures, if pursued more precisely, there would have been a clear reaction to that as well. When initial efforts failed to produce immediate results, State A did not seek help from other states, and it did not strengthen what was already in motion. Ms. President, exhaustion means to try harder, and it means bringing in partners. It means escalating the pressure through every available legal tool. What State A demonstrated in 14 months was not the clear exhaustion. Thank you.
Ms. President, members of the court, in response to your question concerning the legal validation of R2P in relation to the Pact of Peace, we'd first like to acknowledge that the Pact of Peace and R2P do share similar goals and wording responding to mass atrocity crimes. However, it is up to this court to determine the legal validation of R2P in this case. In response, we would like to further direct the court to the specific language used in the Pact of Peace. Parties shall act jointly and in cooperation with the United Nations, and that parties must seek peaceful means to protect affected populations in correlation with the use of force.
Counsel, you have 5 minutes remaining.
The only case of force accepted by the Pact of Peace is when states work collectively, which is not the case here. Furthermore, State A, as a member of the United Nations, did not work in cooperation with the United Nations, rather it seems to work against it. Furthermore, the situation must require that State C had failed to protect their own population, according as written here. However, this is not established by the facts of the case either. State A admitted today in their statements that they, quote, interpreted the law beyond its original meaning. It is not in the authority of an individual state to determine the meaning of, or in this case, spirit of, the law and then further apply it according to their own new definition. The right to interpret the law applies to the court alone. Likewise, state has reinterpreted the definition of exceptional humanitarian situations. For example, State A has used harsh verbatim in this court, yet they have failed to establish that this was an exceptional situation. Rather, they have used unsourced numbers behind their argument, and they have failed to provide evidence on whether it was radical groups or government forces that caused people to die and be displaced. Therefore, while R2P and the Pact of Peace share similar wording, the overall legal application of R2P is unfounded in this case. Therefore, we ask the court to find State A's action contrary to international law. Thank you.
The court thanks the agent of State B. The court now invites the agent of State A to deliver its rebuttal. Madam Agent, Mr. Agent, you have the floor.
Hello, everyone. My name is Nelly, and now I will answer to your questions. Honorable Judge, State A acknowledged that paragraph 139 of the 2005 World Summit Outcome documents emphasizes collective action through the Security Council under Chapter 7. However, State A submits that this framework must also be interpreted alongside the broader purposes of the United Nations Chapter, including the protection of human rights and population from mass atrocity crimes. State A is not arguing for an unrestricted right of unilateral intervention. Rather, State A submits that this case concerns exceptional circumstances where mass atrocity crimes were occurring, peaceful measures had followed over an extended period, and the Security Council was unable to act because of political deadlock. Under these extraordinary facts, State A relied on the doctrines of necessity, proportionality, and humanitarian protection reflected in international practice, and the responsibility to protect framework. The intervention was limited strictly to civilians' protection and was not undertaken for conquest, territorial gain, or political domination. Thank you.
Honorable judges, to answer the second question, State A respectfully submits that extensive peaceful and diplomatic measures had already been pursued before the intervention occurred. Now, the record shows that negotiations, mediation efforts, diplomatic pressure, and economic sanctions were attempted. And all of these were attempted over a prolonged period of the 14 months. However, despite these efforts, civilians continued to face large-scale killings, displacement. State A therefore concluded that further delay within the Security Council would realistically prevent additional mass atrocities. State A does not argue that the Security Council procedures are irrelevant. Rather, State A submits that the prolonged international deadlock cannot create a situation where international law becomes incapable of responding to an ongoing humanitarian catastrophe. Accordingly, State A only acted after peaceful alternatives had been exhausted, and only to the extent necessary to protect civilian life. Now, we cited the Gabchikiwo case because it recognizes that when such essential human interests are at stake and there is imminent risk, all other means, including the 14 months diplomacy, have failed. A state of necessity arises, and that justifies our action. Thank you.
The court thanks both agents for their submission. The court will now retire to deliberate. The session will resume in 25 minutes when the judgment will be delivered. Thank you.
Dear guests, during the 25 minutes break, our organizing team is conducting interviews. If you would like to share your thoughts on today's proceedings, please kindly follow our team's guidance. Your participation would be highly appreciated.
If
What do you like better, like this or like this? That's good enough.
Two minutes, okay.
Here, rebuttal, judge, delivery of judgment, group certified distribution, and then maybe in open discussion. I don't know what might happen.
Dear guests, we will continue our session in 2 minutes.
Hello. Hello. We would like to request everyone to please take your seats. One more time, we would like to request everyone to please take your seats. We hope everyone get their seats. We would like to request judges to please get in.
Please stand up.
We would like to request everyone to please stand up.
Please be seated.
Thank you.
The session is resumed. The court has reached its decision and will now deliver judgment. In the case concerning the lawfulness of the military intervention in the territory of State C between the Republic of State B as the applicant and the Republic of State A as the respondent, the court, composed as above, after deliberation, delivers the following judgment. On the 14th of March 2026, State B filed an application instituting proceedings against State A concerning the military intervention launched on the 1st of January 2026 in the territory of State C. State A filed its response on the 21st of March. Both parties presented oral pleadings before the court on this day, and the court has heard the agents of both parties. The court has jurisdiction in this case by the virtue of Article 36, Paragraph 1 of its statute and Article 4 of the Pact of Peace, to which both parties are parties without pertinent reservations. Jurisdiction has not been contested. The court is satisfied that it is properly seized of the dispute. The court takes as established the following facts, which are either common ground between the parties or have not been seriously contested today. On the 1st January 2026, State A deployed armed forces in the territory of State C. The intervention was undertaken without the consent of State C and without authorization by the Security Council of the United Nations. State A continues at the day of this judgment to maintain a military presence on part of the territory of State C together with a small coalition. In the period preceding the intervention, the situation in State C had given rise to large-scale civilian casualties and displacement. The court accepts the figures placed before it: in excess of 50,000 civilians killed and over 2 million persons forcibly displaced. The court also accepts that State C was engaged in conduct directed against its own civilian population, including the obstruction of humanitarian assistance. The court further accepts the parties' common position that during a period of approximately 14 months, diplomatic measures, mediation efforts, and economic sanctions were undertaken by various states and the United Nations bodies. The court records, as a matter of fact, that the Security Council was seized of the matter during that period, but did not adopt a resolution authorizing the use of force.
The central legal question in front of the court today is whether, whether the use of force by State A in the territory of State C, in the absence of consent, and of Security Council authorization, can be reconciled with international law, and in particular with Article 2, Paragraph 4 of the Charter of the United Nations and the corresponding provisions of the Pact of Peace. State A maintains that its action was justified under the responsibility to protect doctrine, under the doctrine of necessity reflected in Article 25 of the Articles on State Responsibility, and under an emerging humanitarian exception evidenced by state practice, including the interventions in Kosovo and West Africa. State B maintains that a prohibition on the use of force admits only the exceptions provided in the Charter, namely self-defense under Article 51 and enforcement measures authorized by the Security Council under Chapter 7, and that no further exception is recognized under international law.
The court considers the following points to be decisive.
Article 2, Paragraph 4 of the Charter of the United Nations is recognized by this court as both a treaty obligation and a rule of customary international law of fundamental importance. The court reaffirmed this characterization in its judgment in the military and parliamentary activities in and against Nicaragua case in 1986 and sees no reason to depart from it today. The exceptions to the prohibition on the use of force are limited and are well established. The Charter recognizes, too, the inherent right of self-defense under Article 51 and enforcement measures authorized by the Security Council under Chapter 7. State A has not invoked the first, and it is common ground that the second is absent. The same framework is reflected in the Pact of Peace. The court has noted that State A relies on Article 1, Paragraph 3, and on Article 2 of the Pact, and submits that these provisions read in good faith and in light of their object and purpose, contemplate cooperative action to prevent and respond to violation of international humanitarian law. The court accepts that the Pact contains such cooperative obligations. It does not accept that those obligations confer upon any individual party a unilateral right to employ armed force against another state in pursuit of them. To read Article 1, Paragraph 3 as conferring such a right would be inconsistent with Article 2, Paragraph 3 on the same pact, which preserves the prohibition on the use of force save as authorized by the Charter.
The court turns to responsibility to protect. The doctrine was adopted in paragraphs 138 and 139 of the 2005 World Summit Outcome Document. Paragraph 139 expressly provides that the international community is prepared to take collective action in a timely and decisive manner through the Security Council in accordance with the Charter, including Chapter 7, on a case-by-case basis. The text on which State A itself relies thus directs the response to manifest failure through the Security Council and not around it. Nor does state practice in the period since 2005 disclose the consistent practice and corresponding opinion juries that would be required to establish a customary rule permitting unilateral humanitarian intervention. The interventions cited by State A do not support such a rule. The interventions undertaken by the Economic Community of West African States in Liberia and Sierra Leone were conducted under the framework of a regional organization and received subsequent endorsement by the Security Council. The intervention by the North Atlantic Treaty Organization in Kosovo, while undertaken without Security Council authorization, was widely characterized at time as exceptional and was described in the report of the Independent International Commission of Kosovo as illegal, even where it was thought legitimate. Such an instance cannot be found a rule of customary international law. The court therefore cannot accept that the responsibility to protect, as it presently exists in international law, supplies an additional exception to the prohibition on the use of force. The doctrine is best understood as a political and moral commitment channeled in its third pillar through the Security Council.
State A has invoked the doctrine of necessity as reflected in Article 25 of the Articles of State Responsibility and has cited this court's prior recognition of that doctrine. The court accepts that necessity remains recognized if narrow circumstances precluding wrongfulness in the law of state responsibility. The court is, however, unable to accept that the conditions of Article 25 are satisfied in the present case. Article 25 permits the plea of necessity only where the act in question is the only way for the state to safeguard an essential interest against a grave and imminent peril, and only where the act does not seriously impair an essential interest of another state. The court need not decide in the abstract whether the protection of foreign civilian populations may ever amount to an essential interest of the intervening state within the meaning of that provision. It suffices to observe that the use of armed force against the territorial integrity of State C seriously impairs an essential interest of that state, which is its sovereignty and territorial integrity. The second condition of Article 25 is therefore not satisfied. The court further notes that Article 26 of the same articles provides that nothing in the chapter on circumstances precluding wrongfulness excludes the wrongfulness of any act not in conformity with an obligation arising under a peremptory norm of general international law. The prohibition on the use of force in interstate relations is widely recognized as having such a character. Necessity cannot, accordingly, be relied upon to justify what would otherwise be a violation of that prohibition.
State A submits that 14 months of diplomatic mediation and sanctions measures had failed, and that further peaceful efforts would have been futile. State B submits that those measures had not been given sufficient time or coordinated support to amount to genuine exhaustion, and that State A itself did not meaningfully contribute to them. The court does not consider it necessary to determine in the abstract when peaceful measures will be deemed exhausted. The court observes that the failure or insufficiency of peaceful means cannot, of itself, supply a legal basis for the use of force outside the Charter framework. The existence of two exhaustively defined exceptions to the prohibition on the use of force does not yield to a third merely because the first has not been invoked and the second has not been achieved. The court further notes that the Security Council during the relevant period was actively seized of the matter. The fact that the Council did not adopt an authorizing resolution does not, of itself, amount to a positive prohibition. But neither does it transfer the individual member states the authority that the Charter has conferred upon the Council. Inaction by the Council leaves the prohibition on the use of force in place. It does not permit individual states to act in its stead.
The court further observes that on the facts admitted by the parties, State A continues to maintain a military presence on part of the territory of State C, even on most generous view of the lawfulness of the original intervention. The legal justification for that initial action does not, without more, extend to an open-ended occupation following inconclusive discussions in the Security Council. The court is bound to take this into account in formulating remedies.
For these reasons, the court unanimously finds that it has jurisdiction to entertain the application filed by State B. The court finds that by launching and continuing a military intervention in the territory of State C without the consent of State C and without authorization of the Security Council of the United Nations, State A has acted in breach of its obligation under Article 2, Paragraph 4 of the Charter of the United Nations, and under the corresponding provisions of the Pact of Peace, not to use force against the territorial integrity of another state. The court finds that the responsibility to protect, as expressed in the 2005 World Summit Outcome Document and in the practices of states to date, does not authorize the use of force outside the framework established by the Charter of the United Nations. The court finds that the doctrine of necessity, as reflected in Article 25 of the Article on State Responsibility, cannot be invoked to justify the conduct of State A in the present case. The court finds that State A is under an obligation to cease forthwith its military operations in the territory of State C and to withdraw its armed forces. Unanimously rejects all other submissions of the parties. Done in English, this is the 16th day of May 2026 at the seat of the court at the National Assembly of the Republic of Korea. The session is closed.
네, 맞아요.
이걸로 하고 마이크를 이걸로 해. 이걸로 하시고 그다음에 요거는 소감. 사람들 after certificate.
For the 소감 they use.
그래.
The teams.
이거는 우리
소감.
이거는 얘한테 하지 말고 샤크보다는 이거 사회해야 되니까 다른 사람들
네, 다른 분이 하면 좋을 것 같아요. 지금 시작할까요? Shall we start now? Okay. Ladies and gentlemen, please take your seats. We will resume our certificate ceremony. They will just sit? Okay. The judges have reached a verdict. Congratulations to all parties. We will now begin the certificate ceremony. As I call your name, please come forward to the stage to receive your certificate. First of all, I invite to the stage Ms. Arafe, the coordinator and supervisor of today's ICJ mock trial. This certificate is presented to Arafe for supervising and coordinating 2026 Iwik Model UN ICJ. Congratulations. Next, Francisca Dahmen.
Am I audible? Okay. First of all, good job, everyone. I think we all did a very, very good job, and it all those weeks of preparation led up to this fantastic and very successful day. And I want to first of all congratulate both states today for their submissions. It was very, very fun as a judge to judge your speaking and submissions today. Thank you.
Thank you very much. The next certificate goes to Samuel Dirk Bosman from Judges team.
Yeah. Thanks everybody for coming to see us today, and thanks to the states for participating. I think it was a very fun project to work on for the past weeks. And yeah, we had great fun. We had great fun.
And next certificate goes to Junhee Kang from the Judges team. Congratulations. Congratulations.
So guys, it was an honor to be part of this amazing event. And thank you all of State B and State A. And we did great job. Thank you all.
And the next certificate goes to Jaden Lee from the Judges team. Congratulations.
Hello, everyone. Thank you for, I guess, this entire opportunity. I think it's really great to have things like this, especially when it comes to global issues like R2P and state intervention. So I would like to just thank both teams, thank all my fellow judges, and also thank you to all the audience who stayed here to listen. So thank you, everybody.
And next, the certificate goes to Lim Lee from the judges team. Congratulations.
Hi guys, I also think this is a very special experience we get to do, and I really want to thank all the secretariats and all the people who coordinate such a special project. It really helped us think about how the limitations of law, and when it comes to international law, how like we have to think about every side and like even the civilians and all that stuff. So I think it was a really great opportunity. Thank you so much.
The next certificate goes to Florence Che from Party A. Congratulations.
Excuse me, where are you going? Mike is yours.
Okay, thank you. Thank you so much for this opportunity. It was weeks of intense preparation from me and my team, but we are grateful for this moment. And I want to say a special thank you to Ms. Arife, because she was wonderful, especially bringing me on board. And thank you so much for this opportunity, Arife. And on behalf of my team, thank you.
And next certificate goes to Soyeon Hwang from Party A.
I would like to thank everybody for being with us today, and for as someone who would like to pursue international law in the future, this was a really meaningful opportunity. And Party A, I love you guys.
And next certificate goes to Nelia Kuzakbirdieva from Party A. Congratulations.
Hello, everyone. I really thank you for this opportunity, and I really thank you to the Icj and Iwik, because every one of us, we can try to how to work in this system in the UN, and also I hope that everyone in this room will believe that all dreams come true, and maybe one of you, believe and want to work in UN, and I hope you will work. And also, 모두 행복하세요. 감사합니다.
The next certificate goes to Narzulayeva Maftuna Shuhratqızı from Party A.
You cannot leave.
Thank you for everyone, and thank you for guys, and thank you for this opportunity because I explore a lot of knowledge about R2P and international law. Thank you.
And next certificate goes to Daria Lee from Party A.
Thank you everyone for coming here today. Thank you all state members. Thank you judges for your hard work. I really appreciate this opportunity to participate in this special event today. Thank you.
And next certificate goes to Julie Chandler, who is a leader of Party B. Congratulations.
Hello, everyone. I just wanted to add my thanks and gratitude along with everyone else. Thank you, everyone, for working so hard. I especially want to say how grateful I am for the opportunity and thank my wonderful team members for working so hard and always supporting me and supporting each other and as we went along. Thank you.
This certificate goes to Suming Song from Party B. Congratulations.
Hello, this is actually my first time going to one of these events as I just entered university, and I really have to thank my team for taking me around, showing me things and teaching me things when I was worried that I wouldn't be able to contribute to the team. And I really thank everyone who joined this event and for the opportunity. I'm really honored to be here.
And this certificate goes to Party B team member Shifro Bethlehem Asrat. Congratulations.
Thank you, everyone. I'm honored to be part of this amazing opportunity, and I would like to present my special thanks to RFA and all the organizers and founders of Iwik. And I would also like to thank my team lead, Julie Chandler, because this is a result of 4 months of practice and research. And thank you, everyone.
And this certificate goes to Kathleen Ossis from Party B. Congratulations.
First of all, thank you so much for this amazing opportunity, especially for international students. It's quite hard to find in Korea. It was such an honor to be part of such a hardworking team. Thank you, Julie, for everything, and thank you everyone else for working so hard so all of this can be so smooth and have such a fun memory for everyone. Thank you.
This certificate goes to Party B member Qurbanov Jahangir Ibrahimjonovich.
Thank you for everybody. Thank you, Mr. And thank you for coordinator and Arafa. Thank you for my team leaders and all of my team members. Yeah, we are really best team and we are really perfect. Thank you for everybody.
And this certificate goes to Sontakke Mansi Pramod from the Secretariat team. Please come to the stage.
Hello, everyone. My name is Mansi, and I'm a leader of Secretariat team. First of all, I want to thank my team because they work really, really hard. From last 3 months, we are working very hard with everything because we was the mediator to have a communication with everyone. So all goes to my team. Nothing to me, all goes to my team here and there. And after that, I would love to thank Party A, Party B, and the biggest thanks goes to judges team. They work really, really hard because 3 months we was every now and then having communications and texting each other like, what you think, what you this, can you send me this file and everything. But it was a totally amazing, amazing, amazing experience. And thanks to Tapinu to give us opportunity to represent ourselves, and everyone works really hard with their communication skills. Me too. So thank you so much for joining us today. I hope you have a really good day. Thank you.
This certificate goes to the member from Secretariat team, Kayrat Kızı Molder. Congratulations.
Hello everyone. I want to thank all the teams for their hard work, judges, Party A, Party B, organizing team that they organized this event very well, and especially my team and my team leader Mansi, that they cooperated very well and for their hard work. And especially thanks to organizers who provided with this opportunity, especially Arafe, who guided our sessions every week, and for her guidance. Thank you so much, everyone.
This certificate goes to the member of Secretariat team, Recepova Guljahan. Congratulations.
I just wanted to say thank you to everybody participating in this event, for the organizers, for our Secretariat team and organizing team. Arafa, thank you for guiding us. Thank you, everybody.
The following certificate goes to Yuman Fatima from the Secretariat team. Congratulations.
Wow. Hi, everyone. First of all, I would like to thank you, Iwik. Thank you, Mr. Kim, Arifa, for giving us this platform. And thank you to every single team, Team A, Team B, Judges team, and Secretariat team especially. Everyone worked hard since the past few months. And since I'm not from international relation majors, and it's my very first ICJ experience, I got to learn a lot, and maybe in the near future, I might be able to implement such things. And thank you so much. 다들 수고하셨어요.
This certificate goes to Tu Nyang Wind from Secretariat team. Congratulations.
First of all, I feel so thankful to be a part of this very special and precious opportunity. And I would like to thank all of the people who have made it happen, Party A, Party B, organizing team, judges team, and also Secretariat team. We all work hard within the past few months to be able to get where we are. And then as a Secretariat, I was able to see how the arguments are developed. And it was really interesting. And I can really see how much all the parties, all the judges, all the organizing team develop. And then as a political science student, it was really interesting to see all the theories that I have learned play in real life. So thank you.
Next certificate goes to Otwon Tom Obas, to member of Secretariat team. Congratulations.
Hello, everyone. Toma Tuomo Bache from Uganda, the Pearl of Africa. I am very honored to be here, and thank you to Iwik for this opportunity to create the Korean experience. I believe that it's through experiences that we build ourselves into better people, and this has been the opportunity for us to grow and become better people. Thank you very much, and thank you everyone who made this possible. 안녕하세요. 감사합니다.
This certificate goes to Svorov Varvara from the organizing team. Congratulations.
First of all, I thank everybody for participating in this program. I thank especially members of my team for trying so hard to keep up and adapt to our pace of work. I thank all the teams for cooperation throughout the program. And regarding my 소감, it was a very unforgettable experience. I think I really had a chance to learn a lot for my future. And yeah, just thank you, everybody.
The following certificate goes to Gitam from organizing team. Congratulations.
Hi everyone, 안녕하세요. I feel that I have not done much except for photographing everyone, so I hope that at least I took one good picture of everyone else present in this room. But yeah, I can see that everyone has worked really hard, Team A, Team B, party, like all the parties, Arifa, Mr. Kim, everyone has worked so hard, and I genuinely hope that there are more programs like this so that I have more experiences to click people, I don't know. Thank you so much.
And this certificate goes to Efremov Maxim from the organizing team. Congratulations.
I not like to talk a lot. First of all, hi everyone, or as Russian I will say привет всем. I think that such projects like this mock trial and others help us to understand and realize what happened in the real world, what our future steps will be, and to make our decision who we want to be and in which sphere we want to go, and what's our future impact on our relations between governments, between countries, between our cultures, or just between our communities. Everyone here is important. This event was a result of big cooperation of a lot of teams, a lot of people, and everyone is important in our world. Thank you.
This certificate goes to Gagneet Kaur from organizing team. Congratulations.
Hello everyone, my name is Gagneet Kaur and this is my first experience of the Model UN, and I'm very grateful for the organizers to give me this chance to be here as an organizer, and I hope I did my work, and a special thanks to Arya, like she did a lot of hard work, and I hope I helped her in her tasks, and yeah, that's it. Thank you so much.
This certificate goes to Damira Ishanbekova from organizing team. Congratulations. Okay, we will skip her. That's it. So to lead our final segment of the day, I invite Ms. Arafe back to the stage to head the open discussion. We look forward to a vibrant exchange of ideas. Please, Ms. Arafe.
Thank you, everyone. Especially my appreciation goes to the teams, judges, Party B, Party A, and the Secretariat team. I know how hard it is to be focused during the sessions and write, and because I had the same experience. And at times the mic doesn't work and you just lose your focus, and I know. Anyway, you guys really worked hard, and actually it was beyond my expectation. You worked real hard. Thank you again. So, this is a kind of, I don't want to do a lecture here because we heard a lot, and I think that we got the issue in the case. What was it about? And In general, to be brief, it was actually a conflict between legality and legitimacy in international law. Have you guys ever heard about legality and legitimacy, and do you have any idea what the difference is between them? Any ideas are welcome, including the teams, of course, everybody. Sure, yes.
Legitimacy relates with authorization, but legality relates with the paper, the law. But yes, legitimacy is about authorization.
Yes, actually, many people get confused when we talk. I also, when I was a law student, I always got confused. What is legality and what is legitimacy? But you know, as you mentioned, in simple words, we have conventions, we have customary law, right? That we call unwritten law. They are already agreed upon by states, right? So this is called, whenever, for example, a state do an action, we just analyze whether it was based on law or not. So this is the type of, you know, what we talk about is legality. But when we talk about legitimacy, is that, okay, is there any justification to do a specific action when law is silent or when we don't have enough law to do an action? That was the case of R2P, actually. We have it, we have discussed in, you know, international forums, but it is still a big question. It is really law? What do you believe, the judges team?
So this was, I think, one of the hardest and longest conversation we had as a team, especially in terms of R2P. We were kind of in between if we can see it as a customary international law in that case, or if it remains just a custom, because in our case today it contradicted with the with international law itself, and that you have to get the authority from the UN Security Charter, which in this case they did not. So we were also always torn between doing what's like in good faith of humanity and what international law is actually built on. It's to save humans. And in that case, we were also a little bit concerned that if we argue that R2P is not binding, or in that case is like not as strong as international law, that we will kind of undermine the importance or the base of international law. But what we did in the end of our judgment was that that the risk was actually more higher of the abuse of R2P, and because we saw that there was like another motive behind it, and peaceful measures were not extensively tried. So I think there was also a risk of becoming a precedent case, so that in the future other states may use this case just to use international like R2P as a shield. So yeah, I think I got a bit off topic.
Thank you for an important point. Actually, what I wanted to add today is that there is no specific answer in law. You know, for example, this case could be a little modified, and the answer and the judgment of the judges could be different. For example, one thing that I noticed was that, well, in your case, the presence of a state A, party A, was continuous in C. But just imagine that it was just only for 1 month. In that case, would your judgment could be a different one? How do you think?
For sure, because that was one of the key factors, that to this day there's still military armed forces in the territory. And if it's only been 1 month and if there would have been different sources, also I think in terms of sources we have to differentiate if it's the state itself reporting or if there's like NGO on site reporting that, because it's also always the quality of an information. So there's like several factors that can like, even just in 1 or 2 sentences, can like change the complete judgment. And right now it's difficult for me to decide by myself if the whole judgment would have been different, but I think it would have had a great impact because this is not just a minor change. Yeah.
Great point, thank you. Any other ideas from the audience and participants? Or other teams? Anyone wants to actually, anyone have a different idea?
Sure.
As we were developing the case and we were able to make edits to the facts of the case, my team and I discussed about the exceptions, obviously, and we had edited in that State A was far away from State C, and that there had been no previous issues of like conflict between them. If that hadn't been the case, perhaps there was the opposite, where it'd been a continual issue. In that case, then, yeah, it would have had a great effect on the sway of the case, I believe.
Thank you very much. So I have a fundamental question. Actually, we talked about during the session about that the purposes of the international law, specifically that those that are prescribed in the UN Charter, including respect for humanity, right? But in practice, when it comes to practice, we say that, oh, we have the sovereignty of states, we have the positive law. So what happens to humanity at the end? So the question is that if international law prevents basically intervention while civilians are dying, even if the intervention is for a long time, should morality override legality? And that's the case when legitimacy comes in. Because legitimacy is justification for taking some specific actions that are not in the positive law, right? Like, for example, political justifications, moral justifications, humanitarian justifications. And we see that in different cases, like, for example, in Kosovo case, it was illegal, but it was justified. And international community approved it. Oh, it was good, it was necessary, although NATO just intervened without any authorization. But when you see, for example, the Iraq intervention in 2003, no party from the international community accepted it, and they saw that, oh, this is the case of abuse of power, abuse of use of force. So I want to say that what is the border? How can we understand a case could be, even if it's special, it could be approved afterwards by international community or not? Any ideas? Actually, this question is really hard, I know, but it came to my mind, yeah. Any ideas? I know it's hard, I know. But still, yeah, okay, anyway, this type of questions just proves that, well, international law is not perfect. It needs development, right? And me, even as a person who studied international law, still I'm not sure, oh, where we are going. Maybe in the future, well, we can accept R2P as one of the new norms of international law. Maybe, you know, for now, international law, what is important for international law is a state, right? The governing paradigm is a state-centered, but maybe in future, humanity goes higher, right? And in that case, maybe we are not dubious about R2P. We say that, well, of course, R2P is a responsibility of a state. So what we wanted to say that's the reason why we come here and have dialogue with each other and you know, have communication with each other to say that we don't have a specific answer in law, right? That was the case I wanted to say. But any ideas are welcome from the participants too. Any ideas? Any questions? Or maybe from our teams. Do you have any questions? Yes, sure.
Not a question, just a little contribution. I mean, growing up, my dad told me that the law was made for man. The law was made for man. And so it is men, as in humans, that sat down to come up with all these frameworks, to make laws for society, to make laws for schools, to make laws for companies, and therefore the same men can modify this law. So until when will the rest of the world sit when something bad is happening to a country? The point I am trying to make is that, yes, international law talks about sovereignty, that a state or a country has its own autonomy, and that no one dares come in without the general approval of the Security Council. But in this case, there was a deadlock. at the Security Council. And so the very people that were elected to adjudicate on matters concerning security in the world, they were not able to decide. So they did not decide while there was mass killing. It was still ongoing. So until when? So I am not supporting State A because I'm from State A, but that was what we were actually talking about in our group chat. So until when will instances or situations where there is a deadlock at the Security Council, will the world sit aloof and watch mass killings happen? So the law was made for man, but man can modify it. That's what I think.
Thank you very much. Actually, personally, if I want to tell you my personal opinion, I was in favor of Party A. Maybe if I was in the judge, Party A could win the case. But anyway, as mentioned, no specific answer, right? It depends on the situation. But I have a question for everybody. Do you think that when, for example, crimes like genocide is happening, or like in our case, mass killing of people, do you think inaction and silence of the international community could be more dangerous than violating its regulations? How do you think? Have you ever thought about it? Just imagine in a country. Yes, sure. Sorry, the microphone? Yeah. Yes, yes.
Hello. I'm not really sure of the specific terminologies that was used, but however, under the studying the policies and how this usually work, I was also on the side of the State A with the reasoning that that was initially like they made the action and they tried another action without intervening in the country, and that the problem in that case is that it's not going to under the legality and you're like prompting it. And in the past cases, there is also situations where people, other countries had to intervene to another country to save them because their own, as case was given, that their own country, their own government are pressuring and pushing their own civilians, which means that if you're thinking about that you are not knocking and not supporting it, which means it's totally incorrect in the way like how you can get the permission from both of the sides from that country if the country by itself is pressuring the civilian. So in that case, even if it's not legal, even if it's not crossing the state rules, I think the country, instead of being silent, instead of thinking to be on the middle underground, thinking that their own country can be in the danger, they had to do this kind of actions to save those civilians, to save the stakeholders, which is vulnerable people who cannot save themselves, and their own government are pressuring them and killing them. I think in that case, I will be really agree to give for the state. And answering the question, I think it's you morally obligated as another country, even if it's not your country, to do the action and to pursue to save civilians.
Thank you, ma'am, very much. So based on your remarks, do you believe that we can consider that humanitarian crisis and humanitarian considerations could limit the sovereignty of a state?
Are we saving people, or are we looking for the future consideration of other countries breaking the law?
Thank you very much. Yeah. Actually, this topic is also sensitive politically too. We don't want to just enter to political, issues, but anyway, as she also mentioned, well, it could be necessary. Also, it could be really dangerous because it could be abused by states, right? So the question is here is that, well, we have one challenge. For cases like R2P, even the Kosovo, although it was approved by the international community, the case just came up, and after that the intervention was done, and after that the international community came to think about it. So, but law cannot wait for that, right? Law should have an answer from the very first. So this is one of the challenges. And the second thing is that, well, who decides that, for example, an intervention is legitimate, although illegal? The people that are being killed, the states, or the country that actually whose its sovereignty is violated, who is going to judge it? So that's the question. Yes?
Yes, hello, good afternoon, everyone. I would like to answer the previous question about sovereignty. So regarding all the questions that we've seen, we've heard, so it leads to the bigger idea behind these questions. So it leads to how can the world protect human rights without destroying international legal order? So I understand the importance of sovereignty is in respecting the UN Charter because international law exists to maintain global order and to prevent abuse of force. However, I also believe that silence during genocide or mass atrocities can sometimes become more dangerous than limited humanitarian intervention. So history has shown to us, if in some previous or history cases, like the Rwandan genocide, where that delayed action and international inaction can lead to devastating human suffering, whereas earlier we heard from the Party C how thousands of people died. So while intervention should never be taken lightly and must remain appropriate and proportionate and accountable, international law should not only allow sovereignty, but it should also become a shield behind which civilians are massacred. So like in exceptional humanitarian crisis, protecting human life must also remain a priority of international community. So I think that is very important, as well as if I was as a judge, I would definitely also lean towards state A, because maybe because I'm an emotional person, but because lives matter. People's lives also matter. So thank you very much.
Thank you for your good comments. Yeah, sure. If you consider, you see that we have different ideas, right? And it's really hard if it's just a fictional scenario, but just imagine that we have the real case and also with much more detailed facts, right? So that's the reason why the real, sessions in International Court of Justice takes more than a year, 2 years. Sometimes we had a case like all platforms that took around 11 years for judges to decide on it. So, and when you see, of course. And when you see actually the judgments of the, ICJ, you see that, wow, 500 pages, 1,000 pages. How can you think about it and write, in that content? So, yeah, I think this is really one of the biggest, I just don't want to say that because I studied law, but the law is really difficult, and especially international law. And the problem is that it actually gets developing and it's not stopping, and so we just need to get updated ourselves legally, politically, and from about different issues. Nowadays we have environmental issues and considerations. So yeah, that's a really big and hard task. Yeah. Any questions? Yeah. Sure.
So I think regarding the answer, if morality should allow intervention, I think there's a big conflict of interest between legality and morality in this matter, because international norms were made just intervention. Sorry, was normalized, make norms for norms just to prevent intervention that is not necessary. And I think that reshaping the interventions in civilians through morality risks a more flexible approach of the international law that will leads to breaches, possible breaches, because then international law would be interpreted in a more flexible and not so much normative way, more through morality, and morality itself is a subjective element. So I'm not sure that why I agree that civilians and lives should be protected. I don't think that reinterpreting from morality and genocides and crimes of war, which are all elements that are a bit subjective, is the right approach here, because it can lead to really easy breaches of international law.
Yeah, sure, thank you. But I have a question for you. So, you know, as you know, in the UN Charter, we have, you know, the purposes, right? What purpose is more important than humanity, protecting humanity? So what happens to that? If you just say, okay, sovereignty, political independence, what about humanity?
So, So the basic itself of the UN is that to prevent harm. So I think that maybe norms should be, for sure, reasserted, but reassessed. But I don't think it should be based. Intervention should be based on moral norms. That is not. I think it leads to a risk of easy breach. How do we define morality itself? I mean, what is morality in the definition itself? That, and how maybe since it's so subjective concept, maybe something I think is immoral is not agreed by the other states. So how should I justify the immorality or the morality itself of this intervention?
Thank you very much. Yeah. Any ideas that want to challenge that perspective? Sure.
I don't really know if this might be considered as a way of challenging that perspective. However, I feel that we are not taking a couple of points in account. Like, for example, yes, we might be able to say that some sort of military intervention is justified basing our argument in like humanitarian assistance and other factors, but we are not taking into account the fact that that country that we might be military intervening in is a country that is certainly not alone. They do have some other countries that are going to be backing them up, and of course that might cause a bigger issue in the future, and we are not talking about matters that are just going to happen in that specific country, but that might be possibly expanding to some other territories in the future. And I do agree, like in this specific case, I do agree that the military intervention was probably necessary because we had many civilians killed and many reasons to actually proceed. However, I believe my perspective might be a little bit biased because we are like from Latin America, there are many Latin Americans here, and we might be also taking into account what's happening right now with the current situation with the US and things like that. However, I do believe that we have to take many things in consideration, as I said before, and we cannot use humanitarian assistance as a shield. We cannot also use the R2P as another justification to act against the law, but we have to take many things, we have to think about many things over here. And also, I do believe that while in this case it was necessary to do things like this, it is not always like that. We have to protect humanity, just like you said, and I think that's the priority of the UN and the ICJ. So I believe that we do have to consider humans first, and after that we might jump into the law, because just like that team leader said, the law was created by men, so men can modify it, and we can certainly find certain reasons in specific cases to actually get out of the box. So yeah, it might not be challenging it, but we do have to take many other things in account that we might have skipped this time.
Thank you very much. Yeah.
Yes, I will first thank you. I will answer your question in order of importance, I guess. The first one, who should decide about the intervention? It should always be the people, like the victims. And about sovereignty. When people are being killed, I don't believe sovereignty, a state is still called sovereign, but the problem is that many countries in reality, they think that they define their sovereignty. At the same time, if we let other nations define a state's sovereignty, it would also be a problem, because for her question, I also have the same question, but in reality, not in this case, because for this fictional case, it is not mentioned whether, I don't think the state, the intervening state asked for authorization from Security Council before intervening, and the question is that actually, but my question is, I went to ICJ's website, and there are countries and there are cases presented by each country, and I looked into my country, and there's only one case presented, and that case is not related with humanitarian question. It's just another political question, completely unrelated with humanitarian question. So my question is, why are a lot of these cases not even being presented to ICJ? And if State A also, if asked why it didn't ask for authorization before intervening, and for the case of, for the risk of like the negative impacts of intervention, we have seen the Nicaragua-US case. So the Security Council exists, the authorization, the need for authorization exists to limit this abuse, which is caused by, for example, the Nicaragua-United States case. And yes, I would like answer for my question about ICJ.
Thank you very much. Actually, if there is no comment or any idea, I think we need to wrap up the open discussion, and after that continue with group photo. So yeah, thank you very much. That was actually really fruitful session. Even for me, I learned a lot. In conclusion, actually, yeah, I agree with you. What we can consider is now, international law is not an accomplished system. We still expect it to be developed. And it has many deficiencies, of course, we accept it. So as you mentioned, you mentioned two different cases. Also, because I'm really interested in, the cases of nuclear weapons, and also there is a similar case. That's a kind of, advisor opinion about the legality of the threat over use of nuclear weapons. The same question is there that, well, if we use nuclear weapons, many human beings will be killed. But still, the judges mentioned the positive law. We don't have any regulation in law that explicitly prohibits the threat or use of nuclear weapons. So that was the moment that international community was shocked. Oh, we have many things to be developed in international law. So yeah, and we need to take into consideration that what exists in international law is different from what we want and we expect from it. So that's the case where morality comes to the case. Morality, considerations, some, environmental considerations, political considerations, they're all what we wish for the legal system to be accomplished. But we need to see the reality that exists. Yeah, the law is not complete. Yeah, thank you very much, everyone. Yeah, and we will continue with the closing remarks of Mr. Park Yong-sang, the advisor of the Iwik, and after that we take picture together. Thank you.
반갑습니다. IWIK 자문위원 박영상입니다. 이제 행사를 마무리할 시간이 되었습니다. 오늘 함께해 주신 모든 참가자들과 운영진께 그리고 관계자 여러분께 진심으로 감사드립니다. 지난 약 5개월 동안 참가자 여러분 모두가 많은 시간과 노력을 할애해서 프로그램을 준비해 주셨습니다. 오늘 모의재판을 통해서 국제법과 국제사회의 역할 그리고 국제 분쟁 해결 과정에 대해서 깊이 이해할 수 있는 의미 있는 시간이 되었습니다. 오늘 참가자 여러분은 판사, 변호인단, 서기국 등 각자의 역할 속에서 국제재판 과정을 직접 경험하며 매우 훌륭한 모습을 보여주셨습니다. 모두 수고 많으셨고 이번 경험이 앞으로 여러분의 학업과 진로 그리고 글로벌 활동 속에서 소중한 자산이 되기를 바랍니다. 무엇보다 이번 프로그램을 통해서 만들어진 국제적 네트워크와 교류가 앞으로도 계속 이어지기를 기대합니다. 다시 한번 오늘 함께해 주신 모든 여러분께 감사드리며 여러분의 앞날에 발전과 성장이 있기를 기대합니다. 감사합니다.
So I would like to translate his words. So good afternoon, everyone. As we now conclude the 2026 Iwik Model UN Icj Mock Trial, I would like to sincerely thank all participants, organizers, and guests who joined us today. Over the past several months, all of you have devoted significant time and effort to preparing for this program. Through today's mock trial, I hope this became a meaningful opportunity to gain a deeper understanding of international law, the role of international community, and the process of resolving international disputes. Today, each of you took an important roles as judges, legal representatives, registrars, and delegates, and demonstrated remarkable commitment throughout the mock trial process. I hope this experience will become a valuable asset in your future academic, professional, and global journeys. Most importantly, I hope the international connections and friendships built through the program will continue even after today. Thank you once again to everyone who made this event possible, and I wish you all the best in your future endeavors. Thank you. So thank you all of you for joining us today at the National Assembly for this remarkable ICJ mock trial. And to stay updated on our future events and see photos from today, please follow us on Instagram and Facebook. We have many more exciting projects coming soon. Thank you and have a wonderful evening. And now we would like to take pictures all together.
First, all the people. After that, team invites you.
네, please everyone join us for the picture, please. I would like to request everyone, please, palipali. Please, everyone gather together. We are clicking picture together, please.
Just let her announce the judges.
No, first they want to put inside now. And then after one by one. Here. I want to. This picture, after this picture, they're one by one. Okay? Excuse me, can you guys give me side, please? Thank you. Please gather together and little bit closer so everyone will be there. 빨리 빨리야. Yes, yes, please. Everyone, please, Hatsu. 감사합니다.